Migrating to Australia, the podcast where me, Grant Williams, and him, the guy who knows everything, David Bongiorno, Australia's most debonair migration lawyer, who was putting out the warnings about migration agents and education agents, the distinction between the two, David.
I'm always worried, Grant. People who come and make application by way of education agent don't get the unvarnished truths. They get something glossed up and very often leads to disappointment at the end when the education agent is long gone. And it's very sad to see people who have come here with a belief that the course they're doing will allow them to do something further, and I have to tell them otherwise. It's very sad. Education agents are governed by commission. They don't have client interests at heart.
And as we've covered that many times, but if you do want to find a good education agent, go back and listen to our episode with Lara Parra, and she's the example of a good one. And perhaps you could reach out to her if you don't need to reach out to David. Now, David, we've got a repeat offender on today.
We've got an old hand. You might become a regular, Paul. Thanks for coming. Paul Cott and Ballarat, you are a regular.
Thank you.
Now, what we wanted to talk with you about today, something near and dear to our hearts, because we at the Migrating to Australia podcast, our students and love our graduates and love our young professionals who come, because the young bring energy, intellectual capital, a lot of things to Australia. And when they come, they might have casual employment to begin with, or when they finish their course, they might have casual employment to begin with. So we wanted to have a look at casual employment and the changes that have been taking place. Well, what is it, Paul, the last 6 months?
Yes, in the last 6 months, I think legislation was passed saying certain things in about March, and I believe the High Court decided a case which was consistent with that in around June this year.
So people listening might be new to Australia or coming to Australia. Can you explain what a casual employee is and what other forms of employment a person can take when they get their first or second job?
Yep. So casual employment is often stated as in distinction to permanent. So what it means is you're still an employee, but it means that, and I'll talk in terms of the statutory definition now, there is no firm advance commitment as to ongoing work and a particular number of hours. So it's for completely flexible, which is it's a two-way street, both parties, the employer and the employee. It means that the employee doesn't have to work or can work as much or as little as they want. And on the converse, the employer can employ their workforce, their casual workforce, as much as or as little as they want. So there's that flexibility. So it means that you're a casual employee, you can work elsewhere. You can have 3 jobs, however many jobs you want. So employment in Australia are casual, and you've got permanent part-time and permanent full-time, And then you have another unrelated category of worker who are not an employee, but it's not always a clear line between an employee and an independent contractor. So they're a person running their own business, and it may be when I say business, it can be a very loose sense. It doesn't maybe particularly look like business, but they, again, can work whenever and wherever they want and can work for other people. But with them, they have to pay their own super, work out their own taxation obligations, and work out their own work cover premiums.
People who come to Australia and have their first job as students or their first job as skilled migrants, they may have English as a second language. What are the signs to look for from their perspective that they're casual? Because it may not be immediately clear to them.
It might not be. So first of all, you've not needed to have a written contract or a written casual employment contract in the past. You still don't strictly need to, but there's a lot of encouragement now because of these changes, because the contract is primacy, importance over everything else. So it makes it clear now that there will be a written contract which will say casual employment contract, or if it doesn't say it on the very front cover, very soon in the contract, into the first or second page at the most, it'll say that the nature of the engagement. So that's the first thing that they'll see. The other thing that they'll notice is that they will not be working 9 to 5, 40 hours a week. They will be working irregular, probably. Now, that's the other issue into this. In the past, a person would start off doing casual hours, maybe 10 hours a week, 1 week, 15 hours a week the next week, 30 hours a week the next week. And then all of a sudden it would start to change that they were working 40 hours a week every week for years. Then there was that uncertainty created, well, I started off as a casual, but I'm really in effect full time. So now I'm entitled to annual leave and sick pay, long service and all that. But it was at that point in time, the parties had been not really talking about the arrangement, going along as if they were casual. But in effect, if the employee made a court and said, now I'm a permanent and I'm entitled to years back pay, there was a possibility that would occur and that they would be, for want of a better way to put it, invisibly converted over from casual to full-time. Now, if you are casual at the start, and I would say you'll be getting up into the 90 percentile that casuals now will have a written employment contract, even if it's a one-page basic thing. If they start, if you're a casual employee at the start, then you are and will ever remain a casual until you converted. And you'll know you converted because the employer requests conversion or the employer will offer conversion. So it won't be this middle ground of not converting over, but deemed in law to have converted over, where the parties and the employer and the employee don't know that they've converted. So there's that sign of the fundamental nature of casual employment is flexible for both parties, and you will not be turning up on a set day, on a set time, 5 days a week. And the written employment contract, they'll be the two strong indicators that you're a casual.
What interests me, and I'm sure it interests Grant as well, is the statement, a written statement, even a one-page contract. What about, I'm thinking about people who work as glassies, glass boys, glass girls, waiters, waitresses, kitchen hands. Are they going to be in a position to receive a written contract as well?
Yes, they will. Look, not all of them will. There's an encouragement now for employers to get a written contract that specifies the arrangement, and the employer will be encouraged in the fact that previously, and this case went to the High Court, where if you do not specify in the employment contract the casual loading of 25% and compensates for, then there is a small chance that the employee, many years potentially or many months down the track, could make a claim, even though they've been paid casual loading, if it's not specifically set out in the contract, that they could potentially double dip. And that's what happened in a case called Workpac and Risardo, where it went to the full federal court. And the full federal court said that in relation to a coal mine worker, the guy who'd been working regular shifts for many years was not only getting casual loading of 25% of his wages, but he was also entitled to annual leave and long service leave and sick leave. And so there was that potential, business was outraged, that potential for double dipping. So that's it. There's that real encouragement now that more employers, not all, but more employers now will be encouraged to get a written contract that specifies what the casual loading compensates for, because if it doesn't, and if there isn't something like that, there is a small residual right or a claim in an employee to claim both.
How does the employee make themselves aware of that opportunity, for want of a better term? A lot of people who have their first job in Australia are very often reluctant to rock the boat because they're new and they don't know how to read the lie of the land, what they're entitled to. Is there somebody they can speak to, apart from an employment lawyer? They may not have the money for an employment lawyer. Where else can they get information about their rights?
The Fair Work Ombudsman is very layperson friendly. It's not for lawyers. www.fwo.gov.au. Extremely comprehensive, sets all this stuff out. And then if anybody's not sure after reading through the really well set out website with an absolute massive amount of information, even I refer to it, even if they still can't work it out,
Paul, what would happen with the situation now with let's use a glassy, like David referred to, someone who might be working at a nightclub and main role is just picking up the discarded glasses off tables, but that you were regularly working 3 nights a week from, say, 10 p.m. to 4 a.m. and for a year you were regularly working those times. Does that, even if you're given a contract saying it's casual, does the regular ongoing sameness of your rostering arrangement mean that you are really a part-time employee rather than a casual employee?
No, not now. It used to be the UK workers called long-term casuals, which were people who are changing over. But now, if you are a casual at the start, and if you work 40 hours a week for 20 years, but nothing's done to specifically convert you over, you remain a casual.
So your work may be, your hours of work may be regularised and the same year after year, but you will still be classed as a casual.
Unless the employee has requested conversion to permanent part-time, or if the employer has offered conversion and the employee's accepted it.
Okay.
So there's got to be something specific that converts the relationship over.
Okay. Can the employee request it? And if the hours are, as I indicated, they are regular, so the rostering is stable, can the employee request it and the employer say no?
The employer has to respond within 21 days to either yes or no, can request it. The main grounds on which the employer can refuse is on what's called reasonable business grounds. Now, whenever we chuck in reasonable, the phraseology that comes to my mind is how long is a piece of string? So there's that flexibility. But basically, the upshot of it is reasonable business grounds means that an employer can refuse a request for conversion if the work is likely to change, diminish, go away, and that it's not going to be on a long-term permanent basis. That way the employer can then refuse conversion.
When is it in the interests of an employer to do that, from an employer's perspective, when is it advantageous for them to do that rather than bring the person across as a permanent part-time?
Because they might look on a long-term basis, even a medium-term basis, and think that it is not or can't be set in stone as to what our workforce needs going to be. It might change. Business outlook looks a little bit uncertain, 6 months' time, 1 year's time, and because of that, we may well not offer some of our workforce shifts. We can't offer conversion because there's got to be that possibility of that when you do offer conversion, that there will be 32 hours a week set or not. And if there isn't, then that's a reasonable business ground to refuse conversion.
And what's the advantage, looking at it from an employee's perspective? What are they entitled to as casuals? What do they miss out on by being casuals, and what do they get by being permanent part-time, permanent full-time?
Basically, the entitlements. So if you're casual, you don't get annual leave. So if you don't work over Christmas on a Christmas shutdown, for example, for say 4 weeks, you don't get paid. You don't get long service leave, and you do get super. So then you don't get sick. If you're sick, then you can't work, then you don't get paid. So there's that disadvantage for an employee. The advantage for a permanent is that they get all those entitlements. 27th
of September 2021, so 3 weeks ago, line in the sand. What were the changes? There was a period for employees and employers to sort it out for 6 months, yeah? What significance is 27 September 2021?
Those dates are in relation to what's called the Casual Employee Information Statement, which it's an offence for an employer not to provide it. There's an equivalent in the full-time employee sphere, and that's called the Fair Work Information Statement. Again, it's an offence not to provide one. So when all these changes were brought in, there was what you call, I guess, a sunset period where employers were given until the 27th of September this year to provide one. So to become acquainted with the changes, so to give one, where you get them from. They're only a 2-page form. They're pretty basic, but you have to give one. So that's what the 27th of September date relates to.
What are the penalties? You said it's an offence. That's important, perhaps, that employers listening have an idea. What offence do they commit under which act?
The Fair Work Act, it's not heavy, it's not big. I think it might only be $500, but nevertheless, if you've got potentially, it would be an offence for each employee. If you've got 50 employees and you don't give every one of them one, that's 50 times 50, whatever that is. You do the maths. 25,000, isn't it?
It's a lot of money. It's a lot of money.
Yeah,
Well,
it is.
does an employer need to give the existing casual workforce that statement?
Yeah, they do. They had to give one to them as of 27 March.
Okay, so everybody listening who is a casual employee will have cited that information sheet, and everybody who is not a casual employee will have cited the other information sheet.
They're actually a good little source summary of information, actually, because they're 2-page form and they basically set out at the very top, they say what a casual employee is, so they actually define it, and they then set out with nice little graphs and in tables as to what benefits you get from being a casual and what benefits you miss out on in being a casual. So as we're talking about today, these statements have, so they're a good little information tool for employees when they get them.
And so casual employees who really like the work and they know the work is plentiful and let's hypothetically, they're doing the second year of their degree and they've been with the same business for that period of time. When are they in a position to express express conversion? How long do they have to wait?
12 months. They have to be there for 12 months. And then the last 6 months of their work basically has to be regular and systematic. What the old terminology we used to call in the unfair dismissal jurisdiction, that a casual couldn't make an unfair dismissal claim if they weren't systematic. Now you can make a request for conversion if you have been there for 12 months and your last 6 months was regular and systematic hours.
But the employer can say no because our business conditions may change.
Yeah. In other words, that hours could be reduced, hours could be gone altogether. We will be reducing our workforce, things like that. So they're really obviously predictions. They might be wrong. And, of course, there might be some out there to just say, no, I reasonable business grounds and not give it much thought. So there is an avenue, I think it's to the Fair Work Commission and or the Federal Circuit Court for disputes in this area to be taken to either one of those bodies. So the employee says, well, he didn't really consider it. I think that he should have, and I don't believe he's reasonable business grounds. I've looked into it myself. The workforce is not going to change. I believe it's going to increase. They can take a dispute or a complaint to the Federal Circuit Court or the Fair Work Commission.
These expensive dispute mechanisms, are they expensive to take? Matters of this nature?
The Federal Circuit Court is, yeah. The court so is the Fair Work Commission, not so much.
And is it if someone takes their employer to Fair Work, the relationship's probably maybe not irretrievably broken. How does someone who wins at Fair Work stay in that environment if it's going to be a toxic environment with an employer who is bitter at losing and being forced to reinstate them? How does that work?
You raise a very good point, and it's a discussion I had with an employer yesterday who had not been dismissed but had been demoted, and they wanted to dispute it to the Fair Work Commission. And I said, basically, if you do, you can do that. It's for a what's called a non-dismissal-related general protections application. She maintained that she was demoted because of her race. I said it takes real gumption in a person to basically sue their current employer. That's a real practical impediment to being able to do that. Who wants to do that? Then what could happen then is, as you say, it gets all toxic and the employer just puts his hands in the air and says, I don't want this person around anymore, I'm just going to sack them. And there's no reason for it, no grounds. The employee's without a job. but except for they've got a legal claim, which they may not be able to afford to litigate. So it's a really tough one. It's always very tough, current relationship, to sue your current employer.
But Paul, if that worker was a casual, the employer doesn't need to dismiss them. The employer is within their rights in managing their business to just not roster them on. So you, as an employee, you basically have no way to pressure your employer.
Don't they call that constructive dismissal?
A constructive dismissal is something slightly different. It is where the conduct of the employer is that bad to the employee that they almost had no choice but to resign. It's a very high bar. Grant raises a very good point in that it's a thing that I've often thought about, where I'm acting for an employer in the unfair dismissal application, and it's a casual who's been terminated. And I've always raised the question, or had it in my mind at least, not necessarily been able to raise a question with the person who did it. Why didn't you just not give them any more shifts? Rather than end up here in the Fair Work Commission.
I think, Paul, I heard Sally McManus talking about this recently, that this decision and this change in practice means that employers no longer need to go through the process of dismissing a casual. They just now don't have to give them any hours. That's actually spelt out in the information statement, that there's no obligation for ongoing employment or for ongoing hours, any level. You don't have to specify any level of employment to be expected. So that seems to be a shift in the balance of power in the casual employee-employer relationship, that now an employer doesn't need to dismiss you. They can just say, nothing for you this week, sorry.
Well, I think they've always been able to do that. And it's probably, as a result of change, it might be too soon to tell whether there will be a shift, in that employers will now be more alive to the fact that they can just not give them any more shifts. They've always been able to not give them any more shifts. And when these things happen, there's always the employee says, I worked 40 hours a week for the last 5 years. And the employer says, no, you didn't. You months off 1 year, and you took 3 months off another year, and you didn't work. There's always that dispute as well. And maybe that's what it comes down to, is the employer didn't really think that they were employing them full time. And the employee considered that they did. But the employer, if they really genuinely thought they didn't employ them on a full-time basis, didn't need to terminate their employment. They accept the fact that it does tidy their relationship up, and it makes clear that no more shifts will be given. I've never run a business before I've had to hire and fire, but I would be myself. You can very lawfully just not give them any more shifts, not ring them. They might ring you up and keep saying, or keep sending emails or texts, when am I going to get another shift? When am I getting a shift? Maybe that bothers them, so they just terminate them. Maybe that's what happens.
Obligation in that sense, if they do communicate and ask for shifts, people might be eager and needing the money. Is there an obligation on the employer to respond and say no in writing? Or
not really. Not unless there's something in the employment contract to that effect, which I think would be rare. Unless there's something in the enterprise agreement that they've entered into, there's not. It's just a matter of fairness and practice. By the time there is that line between something's illegal and something's appropriate, that wouldn't be illegal, but it would be highly inappropriate and not best practice, because then you've got an employee who's not getting responded to, who gets pissed off and then goes and badmouths that employer to other people. It's just not good business practice.
The other issue, Paul, is that we've been seeing a lot in the news about the Great Resignation. It was covered in America a lot in the last couple of weeks, and it's been covered here, and that it shows that between 40 and 50% of all employees say that if they had the opportunity, they would ditch their current employer. So it's probably going to be much harder for employers to actually get quality workers, because most people, in effect, don't want to work for you. Doesn't matter who you are. It's almost a majority of people who don't want to work for you.
I think that's human nature. I think people just would prefer not to work and prefer. Work's not fun. I remember my dad saying to me many years ago, "Don't expect to turn up to work and have fun day after day. It's not going to be fun. There's going to be a lot of drudgery, a lot of stuck in a light. There's going to be things you hate, there's going to be people you hate. There's things you do that you hate. You have to learn to live with it and put up with it." So I think that's just human nature. People get solidarity with their fellow employees by being able to bag out their employers or bag out the workplace. It's just, and then they do these surveys about, would you resign? Well, yeah, I would. If I get something better, I would. But I think that's what that means.
But the gig economy is changing things as well. That a lot of that sort of unskilled work that was highly casualised has now been turned into gigs. So, yeah, I think employers in a way need to be careful what they wish for.
Can you tell us,
Yeah,
Paul?
they do.
Go on with that thought, Paul.
I was just going to say...
sorry, Paul.
Yeah, with the gig economy, that's then morphing into the area of Uber and Deliveroo drivers and all those types of people. And whether those drivers or riders were running their own business. The gig economy is really bringing into stark reality that some people who look like they're employees are not, or they're independent contractors, and even having an ABN and, say, channeling your money through a bank account that says ABC Enterprises is not conclusive to say that you're not an employee. I mean, it's counterintuitive to say that an employee has an ABN, but there's that. So we're opening up another completely different and very interesting area, because the High Court has been debating this distinction between an employee and a contractor ever since the 1980s.
What are the 6 key differences between an employee and a contractor? The 6 key, because there's quite a few, isn't there?
Oh, there is, and there's a whole lot of factors, but one of the very most important things is there control over the worker or a right to control. In fact, it's getting down to nitty-gritty. It's more than now the right to control. Does the employer or does the hirer of the worker have a right to control the manner in which and the times at which and the methods by which and the places at which the work is done? So the right to control is a very big one. And then they came up with what's called a multi-factor test, where you look at all the factors and you throw them in and it comes out and see what comes out in the wash. So do they wear a uniform? Are they allowed for other people? Do they get deducted out of their payments before they receive them? Is super paid for them? Who provides the tools? All those various things. Is there a written contract, and what does that say? What do the parties regard the relationship as? If both parties are calling it you're a contractor, then it's more likely that you are a contractor, not an employee. So there's a whole series of factors that go into it. Also, I think, at least on the ATO website, there's a decision tool where you throw in a whole series of questions. It's for tax purposes anyway, although you can use that as evidence in other contexts. It comes out with an answer. Throw a whole series of answers to questions in, and it comes out with an answer. Are you a contractor or not? And I think that on the Fair Work Ombudsman website, there may be another tool too where you throw in a whole series of questions, because in any exact situation, it can be unclear, and that's why the issue has gone to the High Court, because by the time cases reach the High Court, it may well be that 5 judges have decided the issue one way and 4 have decided the issue the other way. It's that finely balanced that the High Court's at as well. And it all started off with a case called Hollis and Verboo in 1982 or thereabouts, a series of bicycle couriers. And the issue went all the way to the High Court as to whether they were contractors or employees. And even that was a split decision. So there's a real minefield of uncertainty there.
Students who are here and have braved the elements, financial, fiscal, everything, and they're still here and they haven't left, and they're writing nightly for Uber, what comfort do they draw from this? What knowledge can they draw from this podcast we're having with you? Are those who work at Uber, have they been legally determined as contractors or employees, or is it still ongoing?
It is still ongoing, and it's even still ongoing in the UK. I think their highest court is deciding, or has just decided it. If there is a contract at the start, a written contract, as we talked about before, even a one-page thing, then that will be highly conclusive as to what the arrangement is. It's really hard to give a black and white, clear-cut answer to someone who's all of a sudden says, well, hang on, I need to know, or I want to know which one I am. Am I a contractor, or am I a casual, or a permanent staff member? I don't know. The thing about if you're a contractor or if you're a casual, a very advantage about either of those relationships is that you can do other work. So that may not be your only source of income. So you may be able to earn, you probably can earn income doing other things, especially if you're only getting a small amount of hours, 10 or 20 hours a week. The nature of casual employment or being a contractor is that you are definitely entitled to do other work for other people. And with a more flexible workplace, hours of work have come away in the last few years from just purely 9 to 5, Monday to Friday. You work nights, you work weekends, various things like that. So it increases the flexibility available now for workers who want to spread their wings and learn other fields and earn other income.
Somebody's listening and they're paid 20, 22 an hour to deliver food for Uber, and they like delivering food for Uber, and there's a dispute. What does somebody do in a casual role if they have a dispute with their employer? You talked about somebody you had who wanted to sue on account of race. That's a very sad position for the poor person to be in. But what does someone do if they've got a dispute with their employer? How do they approach them directly, or what would you advise people do before they come to Paul Cott for employment law advice?
I am a big fan. I know it doesn't always work, and it can be very intimidating to do this, but really have an open, honest, transparent communication with the employer and say, look, I might be wrong. I haven't been in Australia for too long. Could you please explain to me? I have a question or a concern about a certain issue. Please explain to me. Then if you don't, then there's the Fair Work Ombudsman. I'll keep going back to that. You don't necessarily need to see a lawyer. The workforce in Australia now is increasingly non-unionised. You do have a union. That is an option. I'm not commenting today on how effective an option that is, but if they're in a union, then that's what they're there for. They're paying the dues. There's JobWatch, a very common, they're a phone advice service. People can ring up and get advice about pay and entitlements in their workforce. And there is community legal centres in many of the suburbs around Melbourne and regional Victoria. I've got one in the way to me, Ballarat Community Legal Centre. So they're free. They're means tested, but they can often answer simple questions or a lot of these types of questions. So look, there are a lot of sources of help. There's a lot of information out there on the internet. I know that not all of it will be accurate, but if you Google search something and you end up on the Fair Work Ombudsman website, then you can be very assured that the information you get will be correct. And they have a lot of fact sheets. They have template documents, template letters, all sorts of things.
What about the person who's been in a fantastic employee-employer relationship and the employer's really happy, or it's a casual relationship, and the employer is very happy and the casual loves it, and the casual's breaching their student visa and they're working more than 40 hours a fortnight, and then the relationship sours. And what protections does someone who's breached a visa, or from an employment perspective, not from an immigration perspective, what protections does a person who's worked more than 40 hours a week in breach of their student visa have with Fair Work? Because do Fair Work and the Department of Home Affairs, one would assume they share information?
Well, you would think they would, but I don't think it's just automatic. I've never heard of them sharing information. I don't think that's necessarily going to be that crossover, particularly maybe on a systemic basis there would be, but not individual cases, I wouldn't have thought.
Because Fair Work has said they'll be confidential to encourage people being exploited, but I'm talking about it from a mutually beneficial business that turns wrong and there's a breach. I always worry about protections for clients. I advise strictly to adhere to the 40-hour a fortnight when school's in session, unlimited work hours when school's not in session. But I was just wondering if in your experience you come across anybody who had a relationship that worked well that soured, but because they were in breach, they'd been threatened by their employer. Well, we'll tell the department that you've been working more than 40 hours a fortnight, etc. Do you see anything like that?
Yeah, well, I haven't seen anything specific, but that's getting like that, not an actual example, but that's getting into the area of the general protection. So the Fair Work Act has a number of sections that give general protections in the workplace to employees, well, actually not just work employees, also to contractors, workers, that it is illegal or unlawful for an employer to take any adverse action, such as not giving them shifts, demoting them, terminating them, decreasing their pay, or anything, making unjustified allegations, reporting you to authorities. Adverse action as a result of an employee having a workplace right or exercising or proposing to exercise a workplace right. A lot of these things are about discrimination, discriminating grounds. What you're talking about, depending on the exact circumstance, may be something like the employer taking adverse action against the employee for a prohibited reason. There's some attribute about the employee they didn't like, and reporting them could be unlawful and a breach of the employee's workplace rights under the general protection provisions, possibly. Depending on the exact circumstance, there is those protections are there and they're pretty good.
How does somebody make themselves aware of those? What do they have to look for?
Well, look at
what would they say?
Fair Work Act, Section 351. Do that one.
Well,
that's one of the most common ones that are litigated. It'll probably link straight to the section if you search that.
We've always talked about the international student being careful not to work more hours than they are allowed to under the terms of their visa. But are there any repercussions, Paul, for an employer who knowingly rosters people on for more hours than they are authorised to work because of that power imbalance that those workers may be reluctant to not work in excess of the hours that they are legally entitled to work?
So that is a tricky one because the employer is wanting the employee, because they could be a great worker, to work more hours than what the employee is willing or able to give up. It just has to come back to the employee, no matter how hard it is, standing their ground. One of the most common reasons for people wanting casual employment is that they have commitments. They have to go and pick up the kids after school. It's unavoidable. If it's not possible for the employee to do those extra hours that are desired, then the employee just needs to say it's not possible. And so it's a tricky one because then they think, well, if I start doing this, the employee might get angry with me and give me no shifts. So I go from getting too much work to none. It's just a risk they have to take. They just have to have that open, honest, transparent communication and say why the hours that are being piled on are just too much or not possible to continue.
Far be it for me to give advice to casuals, but I think if I was a casual, I would always have more than one employer, just for that reason, that the bucket might be tipped on you at any time. You always.
Yeah, well, that's right. It's the saying. That's right. I think it's the saying is don't put all your eggs in one basket.
Yeah. Then what do they have to be mindful?
Yeah, I was about to say that, David. I do believe, well, I'm not a tax expert, but I think that if you work two jobs, that your second job is often taxed at a higher rate. So it's not as financially beneficial to do that as what you might think. So all of a sudden you start earning income in your second job, and the second job's taxed at 47%. So half of your income is going out into tax. It ends up not often being potentially overly worthwhile.
It's taxed at the front end at the higher rate, your second job, that's correct. But it should even out at tax return time. So that's where you might be getting a large refund. So because you still get taxed on the marginal income overall, over your income overall at the marginal rate. So So, and really, in the way the current law is written, it makes no sense for there to be higher tax on a casual employee working a second job. But I think it's there so that you don't go to find another job. I think it's there to encourage you to be at the beck and call of your first employer. So look, it's hard. It's hard to be a wage slave, isn't it?
Because who knows what the intention was, but it can be disadvantageous, and it shouldn't be. You have to wait till tax time, fair enough. If you pay more tax than what you should, then obviously the principle of a tax system is that you get back to tax time, but you have to wait till then. So, but you're right. Some people have 3 casual jobs because, particularly now in the current economic environment, if one job goes bad and you get less shifts, or it dries up, or it closes down, or various things, you can't work from home, so therefore we have to put you off, make you redundant, make your role redundant, then you can fall back on one job or 2 jobs. So this gives that extra flexibility.
Makes you wonder how many of those employers who are employing people in the second and third job are actually doing the withholding tax in the correct manner, and how much of it is cash in hand.
Yeah, well, that's right. The old cash in hand, cash economy system is something that's always been there, isn't it?
Sorry, David, but I just want you to reinforce that if it's cash in hand and it's not recorded, it has no value for you in your
none whatsoever. If you're claiming Australian work experience, you've got to be documented with tax returns, group certificates, pay slips, contract references. So cash in hand work doesn't count. That's very important for people listening who want to claim Australian work experience points. It must be documented. Paul, while we've got you, can we just dip briefly into something that's state of the moment, right? News tip out, everybody's reading about it. Casuals and getting the jab. What's going to happen with the hospitality space and casuals who want to work?
Oh, well, that's a very good topic. We're getting a lot of inquiries about that. The inquiries we're getting are not so much about casual jab, but work employees in the jab. But casuals in the jab obviously are underneath that umbrella term. But are you saying if the employer is saying, you, Mr. Employee, have to get the jab, and the employee doesn't want to do it, is that what you're talking about?
Absolutely, 100%.
Can I interject with the piece of information from last week? The New South Wales Supreme Court rejected a claim from employees who did not want to be vaccinated and were claiming that it violated their human rights. Now, that was thrown out and shown that the orders from the health minister, because he's actually got the power in New South Wales to mandate vaccination in certain occupations, has stood up. So I think that's a fair pointer for what's going to happen in the rest of the country and indeed international arrivals, David.
Paul, I'm double vaccinated, Grant's double vaccinated. I assume you're double vaccinated as well. What's the story? So casuals and employees, take us back to what you were starting and explain from this state's perspective to begin with what the deal is at the moment, if you can.
With the forced jab?
Jab.
Yep. So in Victoria at the moment, there is a series of public health directions and a whole list of categories of workers that have to have it to be able to work. There's a residual amount of jobs. I've got the directions a few feet away from me. It's nearly every worker.
Sorry, Paul. They would have to be double vaxxed, wouldn't they? Because the customer has to be double vaxxed.
I would think so. I don't know the whole list. There's probably about 6 pages of categories of workers, but I would believe that public-facing roles where relatively close contact occurs would be one on the list. I'm on the list. We're on the list. Lawyers are on the list. The thing that people have to remember about these vaccines, if your employer says, if you're not vaxxed, I'm going to terminate you, it is actually not the employer who's making the mandate or the directive, it's the government. The employer doesn't have a choice. It's a public health direction. Yep. That's a really important point here. So I'm getting inquiries and people are saying, my effing employer is going to sack me, or my effing employer has told me I have to get the jab, I'm sorry. Yes, they are telling you that, but it's coming from above them. The employer, they have a choice. Somebody made a comment a week or two ago to me to say the government's getting businesses to do dirty work. Now, whether that's true or not, it doesn't matter. It's not the government. It's not the employer making the direction. It's the government. Previously to the public health directions, employers were sometimes making their own decision. So SPC, Canterbury and Shepparton, they made their own independent decision, as they're entitled to do, that employees or contractors coming in and out of the site had to be vaccinated. So that was their own independent decision. Now the decision is not coming from employers. It's a government directive that cannot be avoided. And unless and until those public directions are struck down or deleted or certain clauses are struck out, they are law. And there may be a legal challenge along the way or on the way in the pipeline to happen. But unless that one wins, then in Victoria, those directions have to be followed. And it comes down to choice that employees have to make. Be vaccinated or don't work.
It's a really interesting one where people are talking about human rights, and we don't have a Bill of Rights in Australia. We don't have a list of statutory rights, and vaccinations have been forced upon us for a very long time. Your children cannot go to school or to kinder or whatnot if they have not had certain jabs. There are lots of jabs that all of us have had, and they have been mandated. So I can't see that any of these contests to this mandate are going to be successful.
And it's going via some very clever argument by someone that I'm not seeing. I had to give a pretty detailed advice earlier in the week. This person was talking about privacy and constitutional law and the powers of the heads of government to pass laws, all this type of stuff. A lot of it's just airy-fairy, but they were sure of it.
It is.
I said, well, fair enough, but go and see a government or an admin lawyer who may be able to construct arguments like that. But it's not an employment law question.
And
however, it's very important to note that if an employee has a medical condition exemption that's provable in writing, that's a different story.
Yeah.
As a result of that, if the employer then says, well, I'm going to sack you because, they don't have to say it. They won't say, I'm going to sack you for health condition. But if the employer ignores that condition that contraindicates against the vaccine, then we're talking about a potential Fair Work claim. But that's...
Unless they're a casual, and business conditions might just mean that they haven't needed to be given any more work. Just on that point about the exemption, just make sure you get it from a registered doctor and not someone who did a PhD in public health policy.
On the Gold Coast, the lady on the Gold Coast.
That is astounding that people will be waving these things around saying, I've got an exemption. And you go, yeah, that's right. And I got my degree on the internet too, my degree in employment expertise.
Well, apparently there's a little bit of a market now for forged vaccination certificates. You pay the money and what it is. There's always somebody who's going to try to make money out of scams.
Well, I don't know if either of you have done your Services Victoria link your vaccination status to your phone, but it's very easy. So virtually, I would only think that it would be the people who still have a non-smartphone who would be able to say, I can't show you my officially Medicare-linked vax statement because it's really simple to do.
I'll have to get you to show me how to do it, Grant. I was looking at that this morning.
And in fact, I'm just trying to bring it up now so that I can... It's actually I've got it in 3 different places on my phone. So I've got here, I'm in the Medicare app here, proof of vaccinations and COVID-19 digital certificate.
You've done it.
And there we are. It's up there on there. And then if I go into my Apple wallet it's in there as well, which I've got just in case I can't get online. But also Services Victoria, when I check in on the app, it comes up with the green check and the dates of my vaccinations. So I think they've worked it out. New South Wales have now got theirs linked to your vaccination history, which the doctor does when they give you the vaccinations. So I don't think there's going to be many ways for people to say, I think most establishments, I heard one about an 80-year-old during the week who went to get a haircut and she had a paper proof of vaccination, but the hairdresser said, no, I want to see your digital one because the digital ones can't be forged, and they didn't hair. And I think that's going to be the pretty standard state of affairs. You want to come in, show us your proof. You don't want to come in, find somewhere else. See ya. I think that's just going to be the way of the world.
Paul, final question from me. With the economies around the country opening up, is there anything scheduled legislatively and also by mere opening of the economies? Do employees and employers need to look at anything upcoming? Is there anything that they need to be mindful of as we open up?
No, I don't think so. Not in the employment law space, but I think that casual employees need to question whether they have a written contract. And on the other side of the coin, and in a different way, if you're an employer and you're employing casual employees, it is really preferable to create the certainty that there is not going to be any double dipping of entitlements years down the track, that their employment contracts are spick, and not only set out at the start that a casual employee is an employee without a firm advanced commitment to ongoing work as to regular hours, and that a casual loading is paid, and that it sets out, it doesn't need to be a lot of detail, and there is a bit of administrative burden on employers, needs to set out what the casual loading compensates for, which will be annual leave, sick leave, long service leave, compassionate leave and carers leave. And even if you can, to make it even 100% watertight, just set out in dollar terms as much as you can in the contract. So look at your contracts. If you haven't got one, you don't have to have one. Legally, an employment contract is not required. Boy, many times when I form and there's no written contract, it just makes things so much harder. But not just for myself, I don't care about that, for the employee, for my client, to assert their rights.
Now, if anyone is listening and they don't want to go through research, they don't want to do it themselves, they want to get Paul Cott to do the job from Law on Liddiard, how do they get in touch with you, Paul?
So paul@lawonlydiard.com.au is my email address. And the direct line straight through to me without going through a secretary is 0412 483 758. So Ballarat, Victoria, which is a regional town. But you don't. What were you going to say? What was that at, Grant?
You're going to get every spam bloody marketing scammers calling.
Paul,
no different to what it already is.
Can you explain to listeners that the fact that you're in Ballarat it doesn't matter for the purpose of employment law where you are, does it? That's
right. In fact, most of my employment law clients I never meet and never will meet. That's a very common area. It's always great to meet someone, of course, but I have employment law clients around Australia. They can be anywhere.
So if you're listening interstate or in the city, reach out to Paul so he can help you.
You might have to speak to you, Paul, about an ambit claim for podcasters. We're always getting left out, buddy.
Paul Cott, thanks for joining us. It's been great as usual. And next time there's employment shifts, seismic shifts, non-seismic shifts, we'll get you on again because it's always great to have you. Thanks for coming.
No worries.
I've got my last question for Paul, and it's very timely, Paul. Do you think that employers should have been allowed to do the squid game for people? And that's not really nice, is it? Just to kill them if they don't win?
No, I think that would probably become law, I would imagine.
You think that might have that might breach the workplace entitlements somewhere along the way?
I think it would. It's funny how last Saturday and my wife watched the Squid Game. All of a sudden this week, every day I hear about it.
Yeah.
Last Saturday I'd never heard of it.
I tried to watch it when it first popped up on Netflix, and I thought, this is really weird. This won't catch on.
In another life, weird. Paul, it's a rehash. And in a past life, I was an entertainment reporter. And for people listening, if they want to look at the 1982 film with Linda Stone, A Turkey Shoot.
Oh, what a beauty.
And the 2008 Battle Royale from Japan and Hunger Games. It's a hybrid of those three. Yeah. Squid Games is a beautifully produced. It's a very good-looking production, but it's nothing new. It's a rehash of those three series for 2 films and series. Better get to the source. Turkey Shoot. Yeah. So all right, mate. You have a good weekend.
Don't let anyone ever say we don't cover current events.
That's it.
Thanks, Paul.
Great to see you again,
mate. Paul, talking and helping us with employment on the Migrating to Australia podcast, Grant.
And without doubt, Paul is the coolest lawyer in Ballarat.
But it's funny, people love the Squid Games, and I've watched it, and it's very good. It's very gruesome, but it's been done before. Those 2 films, Turkey Shoot, Battle Royale, and the Hunger Games. So it's a very spicy remix of those 3 things.
Well, I'm looking forward to the Hollywood remake of the Squid Games, which I probably call Octopus Corner or something, with Rihanna or someone in the lead role. They'll just switch it up. There hasn't been a new idea in Hollywood for bloody 40.
No, not for a long time. Getting exciting, contradictory news, but exciting news about Australians being able to return and Australians being able to leave and international. It's all beginning to come to a head, and over the next few weeks we'll look at what is happening in the entry-exit space for Australia. Do you think it'll go to plan, Grant? I'm always worried that there'll be a little delay, a little trip, and we'll be set.
Would you like my opinion, David?
Your unexpurgated opinion. I'm hoping that it all goes to plan, but I'm expecting there'll be some hiccups for sure.
I think that if we are accepting tourists back into the country from November 1, if tourists begin landing in Sydney in
Which
November
I don't think they
1,
will. I don't think they will.
While there are 40,000 Australians in the far-flung reaches of the world who cannot afford a ticket back to Australia. And look, we did our little ticket exercise.
Mr. Morrison said they'll be prime priority. The Premier of New South Wales seems to think otherwise.
Well, we did our ticket exercise the other day that seemed to think that $1,500 was the go. Well, no, if you're trying to get in from London or Los Angeles or something, you're looking at 5,000 plus.
Staggering sum of money.
The only people whose tickets are being honoured are business class people. Everyone else is in a game of roulette. And I just think it will be a disaster for the government if tourists are coming in before Australians who are stranded, which is why the Prime Minister very quickly tried to walk back the comments of the New South Wales Premier. And indeed, I think we will be waiting to see what happens when Sydney opens up, because the rest of Australia is not going to be saying to people who have just landed at Mascot Airport, sure, come on. There's going to be, this has got the potential to put all the walls up again that the rest of the country has been winding down for interstate travel. So, look, I don't know what's going to happen. I don't think the script has been written yet. I think we've got it's
a work in progress.
Yeah. We've got to get Australians back. We have to get international students back before we start talking about having tourists coming in from the US and the UK and whatnot. I would like to ask you, what did you think of the plan of the New South Wales government to help fruit growers and vegetable growers harvest their fruit?
With public servants taking 6 weeks of special leave?
Yeah. Do you think, or however many, I think it's capped at 6 weeks, but do you think that's going to catch on around the country?
No chance.
Can you see the South Australian government saying, sure, go and pick the wine grapes for their public servant?
I think the public servant is it compulsory for the New South Wales public servants to go on this 6 week period or whatever it's capped at?
It's not compulsory, but I think that people who look, they've been very grey in how they've talked about it, but But it indicates a couple of things. One, that the National Party and the government, that means basically the government of New South Wales, is completely captured by the agricultural lobby. I think that's the first thing
I'm not saying anything.
The second thing to say is that it may well be that if you are a public servant in New South Wales and you want some leave for your own personal reasons, you may be being compelled to get your personal leave granted, that you may be told, if you want 2 weeks off, you also need to go and have 2 weeks picking fruit.
And Grant, what people don't understand, I've spoken to a lot of wonderful young people who've done the working holiday and the work and holiday visa. What the New South Wales government fails to understand, it's very physical work. It's very physical work. And there'll be a lot of public servants who will not be in a physical position to do it for whatever reason.
We've talked about it a million times before, David. If it paid a living wage, people would go and do it.
It's very hard work.
I don't think people are averse to hard work. That's why there's people who are builders labourers.
True.
They're not averse to hard work.
True. I'm not saying that people are, but I think a lot of New South Wales public servants will be very shocked at the conditions that these young people on working holiday and working holiday visas work in. And that ties back to what you're saying about farmers looking after them a lot better than they do at the moment.
One of these farmers being interviewed on, I can't remember which show, but it was probably on the ABC, because I can't imagine anyone else would have covered it. But they're building new accommodation for people to come and actually pick their fruit, and they're building new bunk rooms and a kitchen and whatnot. Gee, I wonder if they had done that 30 years ago and not made people pay exorbitant accommodation charges in a caravan park or in a hotel, or indeed have to sleep in a tent. Perhaps they mightn't have had 30 years where they couldn't get labour.
Heard a bit about people sleeping in tents.
Well, I've done this work. Slept in tents, and you cook your own crappy meal around a campfire, and you get hassled by the landowner about where you've decided to make your fire.
And I show him a true city boy, Grant. What about snakes and spiders?
Well, I like all those things. So, but the point being, if you know that you need a crew of people every year who temporarily come in, well, put up a couple of dongers, buy some secondhand bunk beds, and don't make it a torturous thing for people to do something that you need done every year. Shearers' quarters are habitable places in most cases, because it's a high value product that needs to be got off the back of the animal every year, and a couple of times a year in some instances. So you invest in being able to get it done. Anyway, look, listeners know my view on this. I just cannot believe that the industry is still so far behind. The other thing I'm really interested in is I wonder what the National Party view would have been. That really, they should be against having pipes to deliver water to your homes, because what about the jobs of all the coopers in all the country towns? And really, why do we have cars? Cobb and Co stagecoaches were a pretty good alternative. Why did we ever build trains?
Time to go, Grant.
Yeah. Well, there we go.
Time to go.
Migrating to Australia. Chase
have a good
David Bongiorno on Twitter. At
David Bongiorno, DavidBongiorno, all one word, at David Bongiorno.
Or you can check him out on Instagram, where I always like to see him, because he comes up in amongst my pop stars that I follow, and that would be David_A_C_Bongiorno.
I never produce a message long enough to go to Reels. I haven't been on Reels. I'm always I think a Reel has to be more than a minute or one. I'm contactable that way. And also we can contact you and me on the Migrating to Australia podcast website. Grant, the website address?
Well, the website address is migratingtoaustraliapodcast.com, but there might be some changes. There may be some changes to that. I may be encouraging David to put some podcasts on his website and pointing everyone there, because that's where the appointments page points to, and that's what we want you to do if you need some migration assistance to get information from someone like David, and the easy way to do it is to go to David's appointments page.
It's good to touch on, and people who are thinking about migrating to Australia to study or as skilled professionals or for partners, reach out. We can talk about your case. We can get specific, the nitty-gritty, and I can tell you what you can and can't do. That's important, Grant. People need to know not only what they can do, but what they can't do, because there's nothing worse than committing to a path of action only to fall down 3/4 of the way because you're not eligible.
And look, importantly, what you can't do in relation to today's podcast is work more hours than you are allowed to. That's pretty important.
People on student visas, the general rule is as follows. If you are on a student visa, no more than 40 hours a fortnight, exemptions aside. When school is in session, no more than 40 hours a fortnight. When school is not in session, unlimited work hours.
So there we are. We've done our bit to be useful this week. Thanks, everyone. I hope you're having a marvelous lockdown.
We are. Ciao.
It's ending soon. Bye.